Welcome back to the Elder Law Out Loud podcast. I'm Carla Ray here with CEO of Family First Firm, Geoff Hoatson, and we are in a brand new space. So excited to be in our lovely new podcast studio.
That's it.
This has been a labor of love from several people here at the firm over the last several months, and finally excited to roll it out. And this is taking us out of Geoff's office, which I'm sure he appreciates as well.
It's nice to have a dedicated space.
Yeah, absolutely.
Much less setup as well, I think.
Yeah, and I think that we're really legit here. So people are going to look at this and say, these are serious lawyers.
That's right.
No,
Super professional.
super professional lawyers. Millennials, two millennials, I agree. I think people can figure
Yeah.
probably because of our humor.
Yeah. I was hoping the what would just maybe throw people off the scent.
That's for men for that. It's touch and grade. So speaking of itching, as we always are, we're going to be talking today about some of the lesser known advanced directives. We have done an entire episode on durable power of attorney because that ultimately is one of the most important documents that you can have in your estate plan. But there are some other options out there that you may want to consider as well. And they're all things that we include in all of our packages here at the firm because we think they're so important. We're going to be talking about not just durable power of attorney, but what in a lot of states they call it a healthcare power of attorney. Here in Florida,
Attorney,
here in Florida, it has a little bit of a different name. So why don't you tell us why we're so different in Florida?
Well, we're different in Florida with everything, it feels like. But the document that, in other states you would refer to as medical power a lot of times. In Florida, it's called the designation of a healthcare surrogate. Operates a little bit different. As a reminder, for those of you who probably saw our power of attorney episode, we talk a lot about that document. And one of the things about powers of attorney in the state of Florida is they go into effect immediately. A healthcare surrogate does. So, unlike a power of attorney that goes into effect when you find it, the healthcare surrogate goes into effect when you then lose the ability to make those decisions yourself. So you don't have to worry about saying, I want to benefit go for a walk, and your healthcare surrogate saying, pull the plug, or, anything like that. Not that they would anyways,
yeah,
but
it's a different job.
Right. Yeah. So the bottom line though is that, it's as long as you can make those decisions, your medical staff, the people who are treating you are going to ask you.
Okay.
Then when you can, then they're going to turn to that person and say, okay, now what? And so I think a lot of it has to do with the fact that we don't allow springing powers of attorney, which means it only goes into when you lose the ability to make decisions for yourself. That we don't have powers of attorney here. It's this designation of healthcare service.
So do you need both? If you have one, do you need the other?
Oh, absolutely. Yeah. Powers of attorney, a traditional durable power of attorney here in the state of Florida is specifically for legal and financial decisions. Anything around stuff, rights, finances, real property, and things like that. The designation of the healthcare surrogate is just all about your medical decisions. And a lot of times people will name different people for those roles. So as an example, in my own family, I'm a elder law attorney and a licensed financial advisor, an insurance agent.
Check.
Check.
Triple check.
And not one type of triple correct. We know.
Valuable to your client.
Yes, for sure. Valuable to them, not as sexy as being able to sing and act.
The student loans are great. Yeah.
Sure. So, because of that, my parents would name me as their durable power of attorney. I mean, they named each other first, but
It would be embarrassing if they didn't name you.
For real, right? They just don't trust me. Thankfully, they do, and they back at them. But over on the other side with the medical decision makers, my sister's a physician. And so they named her as their medical decision maker. Now, I will also say, and this was a story I learned shouldn't say a story, it's a lesson that I learned early, is I had a couple come in, this was early in my career. And they had a son who was EMT and a son who was a accountant. And they named the accountant as the power of attorney, and they named the accountant as the medical decision maker. And I said, well, I don't think that makes a lot of sense. You probably really need to rethink because, the EMT is going to know more about medical things and have a better ability to make those decisions. And they said, you know what, you're right. But he's way too emotional and would never make the decisions that we want him to make.
Oh.
And I was like, geez, that is the right answer.
Yeah.
is you want to name the person who will do what you want them to do.
Yeah.
It doesn't matter what their profession is. At the end of the day, you want someone to do it for yourself. And so, I kind of learned that early on, and that's a lot of the guidance that I give my clients now when we talk about these things is, hey, who's going to make the tough decisions that you want them to make? Whether the is remaining on life support or not remaining on life support. You really have to factor that stuff in.
And that is actually addressed in another advanced directive as well.
That's right.
Not just the healthcare power of attorney.
Bingo. And that's the living will.
Mhm.
So, I'll say, and there's a lot of similar terms in this industry just to really make it difficult for everybody, lawyers. I don't know. But so we have living wills, last wills and testaments, living trusts. So they all kind of sound similar. People use those terms interchangeably a lot. They're all different documents, them and different tools. A living will is sometimes I refer to it as the Tersha document. For those of you who may remember in the late 90s, early 2000s, there was a woman here in the state of Florida, ended up suffering a catastrophic medical event. She ended up basically on life support, reportedly brain dead. Her husband said, hey, she didn't want to live like this. Her parents said, oh, Terry absolutely wanted to live like this. And so they did what any normal people would do. They went and spent a bunch of money with lawyers fighting about this. And, it went up through multiple courts, ultimately went to the Supreme Court, who sided with the husband, and they ended up removing her from life support. She passed away naturally. Now, if she had had a living will, you never would have heard her name, because a living will is where she would have said, hey, I want to be on life support, or I don't want to be on life support. Mm-hmm. This woman, anybody who remembers her, for the most part, remembers the pictures of her that were all over the news, the papers and the magazines. I mean, this was a national deal back then. And they remember this picture of this woman in the hospital bed, kind of wasting away, not looking particularly great. Terry, prior to that, was vibrant, beautiful. Yeah. I mean, I guarantee you those pictures are probably not how she wanted to be remembered.
Sure.
And so if she'd had these type of documents, no one would have ever heard her name. No one would have known, because her wishes would have prevailed. So that's one of the nice things about the living will, is that you really take this difficult decision away from your loved ones. So instead of, a child trying to decide, hey, do we quote unquote kill mom or let mom die, this horrible, pull the plug. I mean, it's just the ramifications of that decision can feel life altering. Mm-hmm. But instead, now they're only carrying out your wishes, the wishes that you've already expressly said that, hey, this is what I want to have happen in these circumstances. And I really feel like it's a blessing to your loved ones, because they don't have to live with that, because they know they made the right decision, because it's the decision that you already made. So
now, if you don't have a living will in place, does the healthcare surrogate get to make that decision?
Yeah, absolutely.
So you definitely want to have both.
Yeah, I always say the living will is a set of instructions to that healthcare surrogate, so they know what decisions you want them to make. So that's simple. That's
a big decision. Now, I hear the phrase DNR thrown around a lot. Is that the same as the living will?
That is a great question. People conflate those all the time. They're not the same thing.
Okay.
So a living will means that you ended up on artificial life support. A DNR means you have died, in the sense that your heart has stopped. And so you can be resuscitated through things like CPR or, defibrillators and things like that to get your heart going again. A DNR says, hey, don't do that stuff. For those of you who maybe have never had the unfortunate experience of witnessing CPR, it is a very violent, and very, I would say, like, visually jarring experience, and your clavicle, not your clavicle, I'm sorry, your breast, what's what I'm looking for here? Sternum, thank you. Sternum ribs always broken through this process. It is, like I said, it's very violent, and recovery is not a fun process. And some people get to later in life and are like, hey, I don't want to go through that.
Yeah.
If it's my time, it's my time. And so a DNR is a different document that says, hey, don't bring me back if I die. That document actually has some requirements. It has to be on yellow paper. So if it is not on yellow paper, it is not valid.
Like Family First Farm branded. It's not yellow because of us.
This is Florida state law.
Interesting.
Yeah, super bizarre. I have seen people color color it yellow to make it yellow. That always makes me chuckle. Technically, it should be valid. It doesn't say.
Why does it have to be yellow?
I think it just because the intention is that it is such an important document, they want to make sure that it has been very intentionally done. Um, but yeah, so it has to be in yellow paper. Generally, you're supposed to put it on your fridge or on the back of your door. Now, I have friends who are paramedics, and how do I want to phrase this? Some of them have said, "Yeah, it's our job to save people," and sometimes we may miss that and just bring it back anyway. So it's not a guarantee by any stretch, unfortunately. Plenty of people that have DNRs do get resuscitated. I don't know if that's a good or bad thing, but
So I know this is maybe outside of your scope because it would go into like litigation, but if somebody who was resuscitated who had a DNR and didn't want to be resuscitated and they had it in plain view, could they file a claim against the people who saved their lives? Would it hold up in court?
So I'm not sure what the cause of action would be, like wrongful life.
Right. Like I went to the trouble of creating these directives and you didn't respect my wishes, but I don't know what the claim would be either, but it's quite interesting.
It is. Yeah. And I've wondered about that as well. It seems like, I do believe that there is a cause of action. I feel like one of my buddies who does medical malpractice said something. There was like a wrongful birth, something like that, in some. I don't remember the specifics of it. Like a child that had significant developmental disabilities, I think, was potentially impacting the life of the mother based on and I think there was some. I don't remember the specifics of it. It kind of stuck. I mean, this is something he told me years and years ago, but I just it's like tucked in the back of my head there. I was like, that seems odd.
Those are the Grey's Anatomy scenarios,
right?
From that only Shonda Rhimes could dream up and write into a show.
So, bottom line, I don't know if there would be a cause of action. Like, geez, this person should have let me die, and I'm upset about it. I'm going to sue because I should be dead. Feels odd.
Now, is a DNR something that you can have done at a hospital? Do you need a lawyer to put it together?
You don't, but it doesn't need to be on yellow paper, so that becomes the biggest challenge. Lots of people print them off online, make sure that they get it, go over to Office Max and go, or Office Depot, whatever. I think it's all Office Depot now.
Okay.
But anyway, bottom line, get yellow paper there, they'll print it out and, put it on their door. That is not a state forum for that. Not like with the powers of attorney and things like that, where there are a lot of specific documents where you need an attorney. The DNR doesn't.
It doesn't need like notarization or anything.
Honestly, you caught me. I don't remember. I think it might actually be notarized, but you don't need a lawyer to notarize it. Right. You can take to your bank or, like FedEx or whatever.
Yeah.
After that, notaries.
Okay. So we've gone over the healthcare surrogate and the difference between that and a living will and the DNR.
Yeah.
When people hear living will, I think they think of the will that instructs what to happen with your estate.
Right.
What is that document actually called?
That document is the last will and testament. And so that's what, we talked about before, how, wills go through probate. That's the will that goes through probate, is that last will and testament. Living wills don't go through probate.
Okay.
Living wills just on artificial life support or off artificial life support. The last will and testament says, here's going to be the executor of my estate. In Florida, we call that the personal representative. But this is going to be the executor. Here's where my stuff goes. If I have my own children, who's going to be the guardians, that sort of stuff.
Okay. And so is that different from the final disposition instructions?
Yeah. So
that's yet another document.
Yeah, yet another one. So instructions for the final disposition of my remains is the really lengthy term for that document. And basically it's all about what you want to have happen with your body, your remains after you pass away. Do you want to be cremated? Do you want to be buried? If you want to be cremated, do you want to have your ashes sprinkled 10 miles offshore or whatever in some reef? Or do you want it, I think this is kind of cool. These pods, they put your ashes in, you become a tree. Yeah. I love that. I was like, if something happens to me young, I feel like I'd want that. So my daughters could come over and maybe visit the tree. Yeah. I don't know. I feel like you'd have to plant it somewhere where the house isn't going to sell or anything. So nobody cuts that down.
Cut the tree down.
Right.
That's dad in the backyard.
Or maybe they cut it down and make like a table or bench or chair or something, and then who knows? I don't know.
Generations to come.
There you go. Yeah. This will be, maybe, I don't know.
That's a real heirloom journey. Is what that is.
My remains and
that's the millennial humor that we have.
Yeah, that's right. Millennial humor for sure.
Okay, so Do you have to have that in a separate set of instructions, or could it live in a last will and testament?
I can live in a last will and testament. I hate that though, because the last will and testament has to be filed with the court within 10 days of date of death. Um, generally speaking, making those decisions, you occasionally have circumstances where family members don't agree about what's going to happen. And having that as a separate document oftentimes is helpful to funeral parlors, funeral homes. They will rely on that document as witnessed and notarized and such. So, because you also name the person who's responsible to do that. And that could be someone different than your executive. But so you kind of list everything out in that document. If you have prepaid funeral policies or whatnot, you can put everything in that separate document just to make it kind of an easy, almost like a workbook or guide to, hey, after I pass away, here's what needs to be done. Where it wouldn't really be appropriate to put all that in the last will and testament.
Okay.
So some people do. I think the best practice is to keep these things separate, because the will should just direct where your stuff goes, who's your executor, who we actually keep the nomination of guardians for our kids separate from the wills as well. I like to have one document that does one thing. And so the last will and testament is for your probate estate. The designation of guardians for my minor children, clearly just for that. The instructions for the disposition of my remains, clearly just for, it makes it so much simpler when everything is separate rather than all kind of lumped together, and that gets messy. Oftentimes you don't really have everything that you need to have.
I think that's a good point too, because I think a lot of times people at certain stages in their lives start to think about putting these documents together. Like right now, my husband and I were talking about putting together our documents, with the firm, and our son is 4. So if our estate doesn't necessarily change, but he turns 18, then if we had the pre-need guardian information in the will, we would need an entirely new will, right? Right. Because it would no longer be,
It wouldn't be relevant anymore.
Relevant at that time. So, okay, that rolls us right into the pre-need guardian.
Yeah.
So talk to me about that document. Is that for elderly and young people, or just for young people?
So it's actually just for people who are of age. And when I say of the age of majority, so 18 and older, because that's where you are specifically designated who's going to be my guardian if a guardianship ever had to be opened. So people say, okay, well, hang on a second, you have power of attorney. Why would you want this? And really the reason is in case somebody were to challenge the power of attorney, if someone were to file for guardianship or something like that, you have a document that says, hey, at the end of the day, in any guardianship case, the judge is the one who's going to make the decision who the guardian is. But the judge will take any preference or, documents into consideration that designate somebody to serve in that capacity. So we put these together kind of as a backup plan or an insurance policy in the event that somebody went and filed for guardianship when there was already a valid power of attorney in place. So that then that power of attorney could bring in the nomination, that pre-need guardian, and say, hey, they actually said that if this exact circumstance happened, I'm the person who's supposed to be the guardian. Now, of course, that doesn't carry the day, but it's weighted very heavily in the judge's decision.
Okay. So what is the document that you were talking about for your minor children?
Yes, that's one designation of guardian for my minor children. And so that's
different for pre-need guardian?
It is because that's what I know.
What in the world?
Yeah, there's
packet is like 30 pages thick at this point.
Lawyers.
Yeah.
But ultimately,
we're not paid by the page.
Right. No kidding. That's not bad. I didn't. But yeah, so that's just a separate document. We say, hey, if something ever happens to me and a guardian doesn't need to be appointed for my children, this is the person that I want to be named. So now to make things even more convoluted, that's great when you get into that guardianship proceeding. But as I think you might be aware, having worked here, as long as you have, and some of our listeners may know, may not know, it can take a while to get in front of a judge. So what happens in the meantime? What happens to those children? We actually have created a document called a temporary nomination a nomination of temporary guardians for my children. There is no legal designation of that here in the state of Florida.
We just made it up.
Something, basically. But it is something that we can rely on. It's a notarized document, we can use, because the worst case scenario is, let's say you and your husband are, knock on wood, this doesn't happen, but you and your husband are out on a date night and you don't come back for whatever reason, tractor trailer, boom, whatever.
Yeah.
And, your son is at home with babysitter. And so, it's now 3 a.m. and the babysitter is like, I don't want to live here anymore. So like, I don't know what's going on. They're not picking up their cell phones. So they call the police because they don't know what else to do. The police show up. They say, oh, geez, we're going to have to get, DCF involved. We need to, there's a minor child here. We don't know where the parents are. We don't know what's going on. DCF will take custody of the child and place them with the foster family to figure out, someone here local. If you have that designation of a temporary guardian, then, hopefully, the babysitter never calls the police because instead she knows who to call those temporary guardians who are generally people that live within like 15, 20 minutes of your home, who your child knows, who could, have your kid until they figure out what's going on.
Yeah.
And so, in that case, it kind of keeps CCF and all that kind of potential nastiness or, challenge out of the process. Because, who could think of anything worse than your child loses their parents and then gets placed with strangers?
Yeah.
To sort through that.
Yeah.
So, just like the worst possible circumstance.
Absolutely. So that's a different document.
Still, yes. Yeah.
Now,
we're halfway there.
My husband and I took a vacation a couple of years back, and our nanny stayed with our son.
Okay.
And was with him for several days in a row.
Yeah.
And she, from the internet, don't judge her, just printed out like a temporary authorization in case she ever needed to take him to the doctor and had something like that happen. And we talked about the healthcare surrogate. We talked about, those other documents that play in when it's medical decisions. But can you talk about the HIPAA release to get information from medical records?
So for those of you who, most people have heard of HIPAA.
Mm-hmm.
It's a health information portability authorization act. And basically what it does, it protects the privacy of your health information.
Mm-hmm.
And it's very onerous. If you've ever worked in the medical profession, you know that everyone talks about HIPAA all the time. There's this huge thing about, making sure that no one violates HIPAA and discloses medical information. Like my lab company just did.
Like 5 minutes before we
5 minutes before we get on the, I get a call from, I had some labs run and she called me and she's like, hey, I'm emailing you your labs. Like, perfect. I opened it up. It says, it's like password protected with your birthday. I'm like, cool, great. I open it up. There's no password and it's someone else's labs. And their name and everything on it. I'm like, cool. So that's wild.
Yeah.
So I call her back. I'm like, hey, so just FYI. She didn't seem the least bit concerned.
Really?
Yeah, surprisingly.
Awesome.
But bottom line is that, HIPAA is designed to protect against that.
Yeah.
And so, oftentimes the HIPAA release document that we put together is designed to disclose your medical information to the people that you want to know, have to know what's going on. You may have a situation where your healthcare surrogate is the one who's going to make the decisions, but you want all your kids to be able to know and get access.
Mm-hmm.
But maybe it's your spouse and kids from a previous relationship. You want your spouse to make the decision, but you still want your kids to know and be involved. So you can name all of them, and it's not an order of priority. It's just, hey, all these people I want access to have access to my medical information. And so, it allows those conversations to be a little bit more open. There's more transparency. There's not as much like, hey, is she hiding stuff? Everybody has access to the same information.
Now, somebody who has that document, they can't make decisions about the treatment that you're receiving.
That's correct.
Okay.
Just have access to info.
Okay. So I sit with our clients when they're coming in and trying to figure out what they need as far as their estate plan documents. And when I go through the list that we just talked about, they feel a little overwhelmed at times. And a lot of times they ask me, are those documents even necessary? Do I need all of that, the whole list that we just went through? So what would you say to people who ask that question? Are they necessary?
Yeah, that's a great question. To be candid, probably not for everybody. And what I mean by that is a particular person may not use every single document before they pass away. But no person knows which documents they'll need.
Right.
We don't have crystal balls. There's no way to know, what your future holds or looks like. That there are all kinds of examples where, I don't think, my children would ever fight about guardianship, or the fact that I've named Billy as my power of attorney. Susie wouldn't care about that. But then something happens. Now Billy's serving. Susie goes and files a guardianship case. And now that designation of the preemie guardian really important for Billy. Most people say, hey, I don't know that my kids will ever need that. They probably won't. I can probably count on one hand of the thousands of these being prepared over the years, probably count on one hand the number that have been used of litigation. But for those people, that document was invaluable. So, we take hey, it's better to have it and not need it than need it and not have it sort of a prediction. That's just, being a risk averse. But that's ultimately our job, is to avoid, potential risk for you and your family, put you guys in the best possible circumstances.
And we deal in worst case scenarios.
Exclusively.
So I think also what's interesting about it is that here at Family First Firm, not to make it sound like an advertisement, but we believe so much in these advanced directives. We include them in every area of practice that we do. From estate planning to Medicaid planning, asset protection, it's always part of the package.
We do not charge separately for them if you're hiring us for any of the other sorts of services we do, like you were saying. So, if someone comes in just for advanced directives, sure, we do charge for that. But anything else, if you hire us for will or trust or whatever, they're included, because I want to make sure that nobody ever puts their family or themselves in a really difficult situation because they're trying to save a couple bucks. So instead, it's included, and it's not anything that if you decide you don't want it, cool, it doesn't change the price because they're free if you're hiring us for these other services.
And for people coming in from a different state who maybe think that they have all their documents in order when they move to Florida, just know that there are some nuances here.
Absolutely. Florida is very unique. You could take a power of attorney from New York and, it might be 2 pages, 1 page, totally fine. Acceptable to do everything you need to do. Down here, you're going to get left out of the bank. So
literally the banks will not take it.
Yeah, for sure. It's a nightmare. So, down here, if your document's less than 20 pages, this probably doesn't have what you need. So there are specifics and differences from state to state. What I always tell people is when you bring docs to Florida, normally they need to be updated. When you take docs from Florida, they're normally fine. When you take them to other states, those attorneys will probably be like, why are we so extensive? Like, this is so
extra.
Yeah. So
why
extra.
is this one document in yellow?
Yeah, right. Exactly. Yes. All of those things. But, they generally don't need to be updated leaving the state because it's just, they're like, well, it works. It's just so voluminous.
Yeah. Yeah. Well, you're going to be thorough if you get them done here. Yeah. So it's good information. Once again, thank you so much, Geoff. And thank you for joining us for this latest episode of Elder Law Out Loud, again, coming from our brand new podcast space. If you're watching this on YouTube, be sure to share this episode with anyone you think needs this information about advanced directives. And if you need help setting up your advanced directives here in Florida, give us a call.